A wise man once said, "If you think strong men are dangerous, wait until you see what weak men are capable of." This is a short video to summarize the two referendums that are taking place on the 8th of March 2020.
So every time we're asked to vote in a referenda, assume we're going to lose some power, that the people are losing sovereignty, because that's always what the issue is. So what does the Irish Constitution say Ireland exists for? Well, it says that Ireland exists for to defend the natural rights, as John said, the natural, inalienable, and imprescriptible rights. Natural rights mean the rights that are necessary to our human nature. The human person is at the center of the Irish Constitution. And because, and what the human person needs to flourish is a balance between the three major institutions of the individual, the family, and the nation, or the larger grouping. It could be the village, it could be the county, it could be the nation. But that balance, when they're in balance, so that they're respecting each other and cooperating, not competing for control or power, the human person thrives in a society. And in our Constitution is designed so that the individual, the family, and the nation would be and have that balance.
The family. So the 39th Amendment to the Constitution will take place on Wednesday the 8th of March. And it's 41.1.1. The state recognises the family as the natural, primary and fundamental unit group of society, and as a moral institution possessing inalienable and imprescriptible rights, antecedent and superior to all positive law. The amendment will be: the state recognises the family, whether founded on marriage or other durable relationships, as the natural, primary and fundamental unit group of society, and as a moral institution possessing inalienable and imprescriptible rights, antecedent and superior to all positive law. The second part of the family referendum, which is the 39th referendum, the state pledges itself to guard with special care the institute of marriage on which the family is founded, and to protect it against attack. So what will be changed in 41.3.1 will be: the state pledges itself to guard with special care the institution of marriage, and to protect it against attack. So in which the family is founded is removed. Also, the words her, home, woman, and mothers will be removed from our articles, or from our Constitution forever. So can we trust our policymakers?
And it's going to fail. And both of them are going to fail. We'll talk about the other one, the carers one, later on. It'll fail because you're not trusted. People are asking, what is the rush? What are you afraid of in the debate? And I have to say, I could not, in my heart, in my conscience, support this in its current form. I cannot support the lack of democratic debate, which is what we're about in this House. I cannot support a government that is so disregarding of the opinions of the elected members of both houses that it will run through its own question to be put to the people. And I think the people will look in and say, what were they afraid of from their own members in the Oireachtas that has driven them to drive this through with such haste?
Whatever you feel about Brexit, you can see how they feel about nationhood. But the family is very interesting. Why? Because when I remember asking a question of Commissioner Spidla, the Commission for Social Affairs, about some impact that an EU policy was going to have on family, and he just looked at me and he said, but the EU has no competency in family. So the EU is post-family. The family does not exist for the EU. They just decided just not to include it. However, they control everything to do with the family. Children, women, workers' rights, everything that concerns a family is an EU competence. But they don't have to worry about the implications to the family, because they don't do family. It's not a competence. So it doesn't matter what the effect of these things.
What is family or durable relationship?
Last week, the Electoral Commission indicated that if a yes vote is carried in the family referendum, a durable relationship might be proved by virtue of being a group of people who get a joint Christmas card or a wedding invitation. So what is your understanding of the definition of the word durable as it refers to durable relationships, and do you agree with the Electoral Commission?
I'd be arguing for a yes vote on both. Firstly, that we recognise a whole range of different families, which the Constitution currently does. Sure, that's my mind. This referendum is, do we want to recognise all families and strive to support all families? Yes, we do.
But how far do you feel it will go in loosening the definition of what we understand to be a family today?
I don't think it will. I think it's appropriate. I don't think it's right for us to start being exactly in a Constitution saying this family's in, this family's out. I think it's appropriate that there is some legal judgment applied to that in each individual case.
Simple as that. The durability issue, we do need a definition. You can hear already senators in this House confused, trying to figure out what is meant by that. So you need to put a meaning on that. You need to, or are you?
The proposed amendments to the Article 41.1.1 of the Constitution would recognise families based on marriage or another durable relationship, creating confusion and inconsistency in immigration and reunification rules, potentially leading to more legal disputes, delays and costs. The amendment fails to address real challenges facing families in Ireland, such as affordable housing, childcare costs, domestic violence and discrimination against disabled persons. It could undermine the existing protection for marital families and impose a one-size-fits-all approach. The proposed amendments leave it to the courts to decide what constitutes an other durable relationship, opening the door for a wide range of interpretations with serious implications for immigration, reunification policies, tax and inheritance rights. The amendment could undermine the existing protection for marital families and impose a one-size-fits-all approach that doesn't reflect the diversity and the complexity of family life in Ireland today. The government's proposal could lead to far-reaching consequences, such as an unrelated neighbour of an elderly farmer being recognised as family and claiming inheritance and tax benefits. This is not a minor change, but a radical departure from the traditional understanding of family. It lacks a clear plan for implementation in law.
The exact meaning of durable relationship is already causing some confusion.
Truffles. Truffles.
Oh, sorry.
Yeah. Truffles. No, I did not. I did not. Yeah. No.
You're getting hungry.
But that issue has come up in some of the debates, so we're very clear. Such a relationship is not covered within the concept of durability, and it's not covered in the expanded concept of the family.
Durable relationships does not have a definition under Irish law, but it does have a definition under EU law, which includes any relationship that has lasted for a substantial period of time. As most of us know, it can take almost 10 years for a case to work its way up to the European Court of Human Rights. So I think it's essential that we have a clear definition now. Why aren't we capable of providing a clear definition of anything in this country? Durable is now becoming a lot like hate. Why did you reject the advice of the Citizen Advice Assembly?
Minister, as you obviously know, Senator Michael McDowell is a very senior lawyer. He was formerly the Justice Minister and the Attorney General of Ireland. And today in the Irish Times, he's once again expressed his view that the referendum to redefine the family could open the door to polygamous relationships being legally recognised potentially. And not only has the Electoral Commission not labelled this as misinformation, but yesterday Minister Eamon Ryan told my colleague that it would be up to the courts to interpret what the new meaning of family was. So my question in light of that then is, if this referendum passes, can the government absolutely guarantee that the courts will not interpret durable relationships to mean polygamy or to include that?
No government can give a guarantee regarding how our courts will interpret the Constitution. To be entering into what I believe is going to be our courts are independent, and that has to be respected at all times. But what I can make the case for is I believe the changes that I will be campaigning for, I'm sure Minister Abbott will be as well, are all about how we can have a constitution now that reflects every bit as equal as other family units within our society, and all we are aiming to do is have a constitution that respects that equality. I very much respect Senator McDougall, respect the points that he makes, and I look forward to the debate that's going to ensue as we make the case for what I believe is a very positive.
Why would you not stall this and allow a proper debate? I think for something as serious as a constitutional amendment to come into this House, to give a couple of hours to two major changes to the Constitution is repugnant to the very House itself and everything we stand for. You've got to have this finished, done and dusted by tomorrow afternoon in order to meet the 8th of March deadline.
Does our Constitution impede the rights of single-parent or non-traditional families?
But the truth is the opposite, that nothing in the Constitution at the moment prevents the Oireachtas from enacting social welfare laws which are just and non-discriminatory to people who are in domestic situations which are differentiated by the fact that there isn't a marriage underlying them.
We've seen the very recent case today of the widower in Tipperary. That court found there is no difference between a marital and a non-marital family in this context, because Mr O'Mara has essentially the same obligations to his children as a widower would have.
In my view, the O'Mara case, which was decided yesterday, demonstrates the absence of a need for the amendment that we're dealing with. And secondly, the majority in the Supreme Court have explicitly held that the present provisions in the Constitution do not prevent this House from doing justice to the O'Mara family.
Are these referendums just a symbolic act, having them on International Women's Day?
My colleague Senator Siri Carney referred to the elasticity of the definition of a family. I actually agree with her. I agree that we should be as elastic as possible to encompass all sorts of families. I also agree with my colleague Senator McGinn. I don't believe there should be a hierarchy of families. A family is what it says on the tin. My colleague Senator McDougall said this is a gimmick, and it is a gimmick. It has all the hallmarks of a gimmick. You want to bring forward this referendum on international women.
And I'm pleased to announce that we now intend to hold 2 referendums on an inclusive concept of the family and the recognition of family care on International Women's Day in 2024.
There is an urgent need for debate, as Irish voters are being misled that the proposed changes are small and symbolic.
This seems to be a gimmick. It is my prediction that this referendum will be defeated.
The emotive approach.
That a family, and in this archaic definition, a family is solely based on marriage. I try not to get upset, but that is a personal insult to me, a personal insult to 42% of the children born in Ireland, a personal insult to my son, a personal insult to any gay couple who want to have kids. And it's just disgusting. It disgusts me that people in this House or anywhere else are now...
There are a great many people in Ireland today for whom these changes will mean a lot. It will make a difference for people like Breda Murray. Breda is a single mother and a grandmother whose 2 eldest children were born in an unmarried relationship, and 2 younger children were born in a marriage that has now ended. She said, and I quote, "There's absolutely no difference in how I love them and care for them, and no difference for them in how they love me as a mother. And yet, right now, our Constitution makes a distinction between those children." As Breda said, Ireland must change this anarchic and discriminatory clause so that all children can receive the same rights and protections as each other, whether their parents are married or not.
Campaign is personal. My son came home from school after learning about the Constitution and the upcoming referendum, and he said to me, "Mum, do you know we're actually not a family in the Constitution?" And I says, "Why is that?" And he says, "Because you weren't married." And I just think that's heartbreaking for him and so many other children in Ireland sitting in the classroom thinking, "I'm not part of something." And it doesn't matter what shape or size your family is, like, we're all family.
Since publishing this bill, I've been approached by people and have been reminded yet again of how hurtful it is that they and their children are still not recognised in our Constitution, in the founding document of our state. And this referendum is our opportunity to put things right. Now is the time to finally recognise in our Constitution those families.
Other possible reasons for changing the definition of family: inclusion or immigration.
I'm thrilled and delighted that today we have launched our interim report on constitutional change from the Oireachtas Committee on Gender Equality. And this report sets out alternative forms of wording as to how we might amend the Constitution to delete the sexist language about women and mothers currently in it, and to provide for a more inclusive definition of family.
The repeal of the Eighth Amendment. They reflect the continuation of our journey towards a more compassionate, inclusive and equal society.
It doesn't necessarily have to be a biological family member. And this is when I want to get to the key point of changing what the definition of family is. This is moving to not just modern time vernacular, but it has serious consequences, particularly when we think of immigration law and proving that someone is family member or family reunification. This will allow that to be accommodated as well. So we're keeping up to space with other communities.
Because you're talking about durable relationships.
Absolutely, yeah.
Is this
more polarisation within the country?
Talk here today about the hierarchy of families. Nobody in my lifetime has ever mentioned the hierarchy of families until today. I have never experienced or heard that term used ever in my life. Any family I have ever encountered in my life, whether they're single parent, cohabiting couples, gay couples or anything else, for me they constituted a family. And I now find myself that we're in a situation here where we're entering into a constitutional amendment, and the first thing out of the blocks was one of your NGOs, the National Women's Council, saying publicly in the Irish Times that this, if a no vote is carried, it gives the state the oppressive role of keeping women from careers or employment. Where is that coming from? Where is that coming from? How can the chair or the chief executive of an NGO come out and say something like this? Show me one instance in this country where a woman was prevented from pursuing her career. I would go.
Okay, so the second referendum, the 48th Amendment to the Constitution, on the 8th of March, it's 41.2.1, and it's the care. In particular, the state recognises that by her life within the home, woman gives to the state a support without which the common good cannot be achieved. And 41.2.2, the state shall therefore endeavour to ensure that mothers shall not be obliged by economic necessity to engage in labour to the neglect of their duties in the home. So these two articles, 41.2.1, 41.2.2, are gone, and it will be replaced by 42b, a new article. So the new article says the state recognises that the provision of care by members of the family to one another, by reason of the bonds that exist among them, gives to society a support without which the common good cannot be achieved, and shall strive to support such. What is a woman? The gender debate.
As a woman, and a woman as a female sports minister that's trying to promote women in sport, I think it's just really regrettable.
Minister, an article in the Irish Times this week by Pat Leahy outlined some fears within government that the so-called Women in the Home referendum might raise some uncomfortable questions for politicians. For example, how do you define a family and what is a woman in the context of the gender debate? So on foot of that article, I'm just wondering, what is a woman in your view?
This is something that the government are discussing, Ben, but it's very important that we get that wording correct. So in relation to the actual wording of the referendum, I should hope that we'd come to agreement on that wording in the coming weeks. I think it's a really important referendum. It's something that I advocated for when I was chair of the Women's Caucus, that this would lead to a referendum.
But do you have a definition of what you referred earlier to being proud of being a female sport minister and how important it is to promote women in sport and so on? So I'm just wondering, do you have a personal definition of what a woman means?
I think that the question is not relevant to the referendum itself, because as in the issue that is pressing at the minute in relation to the exact wording of a referendum and having the referendum is absolutely essential for
protected characteristic. But Michael McDowell and others have noted that the Gender Recognition Act only recognises 2 genders, while the hate speech bill explicitly refers to more genders than just male or female. Your Shannon leader, Senator Regina Doherty, previously said that there are about 9 genders.
Generations ago, there were 2 genders. There were 2 sexes. There still are 2 sexes, but today I think we probably have about 9 genders, and that doesn't diminish any other gender within the gender identity set.
So how many genders are there, and can we get the government's official position on that?
Look, there isn't official position on that, but I'm sure that will all be debated in the course of the debates in the Shanaton.
The implications of a new chapter to our constitution.
The second thing I want to say is this: that this amendment that we are now considering has 2 functions. Number one, it amends Article 41(2). And secondly, it introduces an entirely new article called Article 42B. And just as Article 41 has an teaglach, the family, as its heading, and Article 42A has children as its heading, we are now inserting not merely Article 42A, but a heading into our Constitution, care. So the provisions of the Irish Constitution that deal with care will be the provisions set out in Article 42B. And it's in that context that I want to echo everything that Senator Clonan said. We are providing, as a mature democracy, wording to deal with the whole question of care in a new Article 42B, in language which is patronising and demeaning. And we've heard that phrase used in respect of the existing Article 41 too, but patronising and demeaning for people who have disability and need care. This isn't a family provision because, as I said, it's taken out of the family chapter of the Constitution and it's put into the care chapter of the Constitution. And it says that the state recognises the provision of care by members of a family to one another by reason of the bonds that exist among them, gives to society a support without which the common good cannot be achieved, and shall strive to support such provision. So it's effectively saying that families have a particular duty because of the bonds they have between them, though we don't use the term duty, that's unfashionable now. But they give a support by reason of the bonds that exist among them. And of course, the phrase, the bonds that do exist among members of a family, small f, are ones of duty. That's what it is. It is duty. It's a different term. But they're saying that care is to be given by members of a family to one another by reason of the bonds that exist among them. And how can it be that we now reform our Constitution to provide a new chapter called care and say that it's all to do with what family members give to each other by virtue of the bonds that exist between family members? Where's the state's obligation in this? Where's the community's obligation in all of this? Where is the social responsibility for people who have disability to vindicate their rights? And Senator Clonan is talking about people with disability. And for him, this will be the only constitutional provision for people with disability. And it's being sold on that basis. It's a kind of a mishmash thing that it's being sold on the basis that this is where the state provides in its fundamental law for the whole issue of care. And it restricts care to that kind of care that's given by one member of a family to another by reason of their bonds of loyalty. You know, Senator Clonan told us about his apprehension about what happens when he and his wife pass on and their son will be dependent on the community for care. And he's told by a HSE person that won't his son have a sister. I mean, how bad is that?
The disability services manager referred me to the social worker. The social worker said, "What are you worried about? Isn't your son living at home with you?" And I said, "But what happens when I die? Who'll toilet him? Who'll clothe him? Who'll put his clothes on him? Who'll shower him? Who'll feed him? Who'll watch him for his swallow?" And she said, "Does he have siblings?" "Yes." "Does he have a sister?" "Yes." "Well then, what are you worried about? She'll look after him when you die." And we know from the research that the vast majority of carers in the home, i.e. unpaid carers, are women and girls and siblings.
Removing the archaic and sexist wording.
On family and the life of women in the home has stayed the same. On March the 8th, people will be asked whether they want to change it in two separate referendums. The first is whether or not...
I would very, very rarely say this, but I do feel this about that particular clause. I find it offensive. I don't have a place within the home. I have a place wherever I choose my place to be. I have children. I love them dearly. They're the most important people in my life. But that does not preclude me. My parenting of my children does not preclude me from having a job, from having a career, and from working outside the home as well as within the home. Don't think for a moment anybody who has a job doesn't work within their home as well, because of course they do. I think this is outdated. I think this is sexist. And I do not like the fact that De Valera has put me in a box that I don't want to be in. I would like to see it...
Disgusting. It disgusts me that people in this house or anywhere else are now using this as some kind of a populist, stupid debate. Let's debate intelligently on intelligent things. This is a waste of time. This is derailing something that has to be... The Hearn was written 100 years ago. So it's perfectly normal that we would change wording to keep up with the times.
Important when we're beginning this campaign to remind people what 41.2.1 says. It says, in particular, and that's in the light of the protection for the family, the state recognises that by her life within the home, woman gives to the state a support without which the common good cannot be achieved. And the case law of the Supreme Court is quite clear that that doesn't mean women's place is in the home. It says that the work that women do provides an important protection and tool and support to society and to the common good. It goes on then to say that in the light of that support, the state shall therefore endeavour to ensure that mothers shall not be obliged by economic necessity to engage in labour to the neglect of their duties in the home. That's a statement of intent. It's not a statement of law. It's a statement of intent by the state that it will endeavour or try to ensure that mothers don't, by reason of economic necessity, have to go out to work, essentially, outside the home. The proposal is to change the entire of those two paragraphs and to delete both of them and replace it with what is called in the texts around this a more gender-neutral phraseology in the Constitution.
But all I would say is that if we were really worried about removing something demeaning or allegedly demeaning to women from the language of Article 41(2), 3 words was all that was enough to change it. Parents and parents of children where they appear in the text. But I think that we are dealing with something more than that. We are dealing with virtue signalling.
It's hoped the referendum will take place on International Women's Day, which is March 8th. Now, who's going to mind the children if they close the schools that day?
I just want to say that, this document does not say anywhere that woman's place is in the home. It doesn't say it. One of the things that I find fascinating is that people ignore other bits of it. If you look at Article 45 of the Constitution, it obliges the state to direct its policy towards securing, and these are the words of the Constitution, that the citizens, all of whom, men and women equally, have the right to an adequate means of livelihood, may, through their occupations, find the means of making reasonable provision for their domestic needs. So anybody who says that this Constitution said women should not work, they ignore what's written in it. That men and women were equally guaranteed the right to make provision for themselves by their work.
Or does the amendment place more onus on the state to provide care?
It doesn't even commit the state to much, to be honest. It doesn't commit the state to much. It says it will assist members of families who provide care to each other. And doesn't even say that it will assist them. It says it'll strive to do so. So it's virtually, I have to say, virtually unenforceable in any shape or form. You can't go down to court and say you're not striving hard enough, or you're giving too many funds to the Arts Council, you should be giving it to home care, or you're giving too much money to acute hospitals when home care needs more. Nobody can go down to the forecourts and say to a judge, shift.
No carer should be forced, whether they're a mother, a father, or whatever category they're working in as the primary carer in a house, should be forced out through economic necessity to have a different job or an additional job. That was the kernel of this article that you're now changing in a very, I would say, pathetic manner, without recognising, perhaps, that there was huge scope within that article, as the judges have pointed out, as Susan Denham did over 23 years ago in a dissenting judgment, that article where the woman was in the home and that was given recognition in the Constitution was doing something valuable, but could be interpreted in a modern day concept, not just to apply to a woman, but put an actual value. And she's not the only judge that has actually referred to this. Hers was a dissenting judgment. Other judges have expressed surprise that the existing article has really never been tested. That article where the woman was in the home and that was given recognition in the Constitution was doing something valuable, but could be interpreted in a modern day concept, not just to apply to a woman, but put an actual value. And she's not the only judge that has actually referred to this. Hers was a dissenting judgment. Other judges have expressed surprise that the existing article has really never been tested.
Implications of redefining care to the normal Joe.
Simple as that. The durability issue, we do need a definition. You can hear already senators in this House confused, trying to figure out what is meant by that. So you need to put a meaning on that. You need to, or are you going to do, as Senator Higgins suggested, drive innocent people with limited resources to the courts to get a definition? This is a change to the Constitution. It is unlikely that that change will have to come again for many decades, so it must be right first time. There are a number of amendments that have been placed down. Senator McDougall, for example, offers an amendment to the durable issue, which makes it perfectly clear, in my view. There are other amendments, a number of excellent amendments put down by the Civic Engagement Group. What is the rush? Why are we rushing this forward? I will tell you today, I make a prediction today, referendums frequently turn out not to be about the question, but about that's asking the question. And I can tell you already, the level of opposition to what we're trying to do in this constitutional amendment is growing. And what's going to happen is we're going to waste 20 million euros on a referendum that I don't know of anybody asking for. Perhaps you do, I don't.
Those things, and I do want to say that the provision that we are supposed to be taking out of Article 41(2) was well-intentioned, pro-woman, and was not intended to force women to remain in the home. It merely obliged the state. And by the way, it's not a directive principle of social policy to be found in Article 45. It is a direct obligation, just as much as the provision of aid to education, to private education, is a direct obligation of the state in Article 42. The provision in this case found expression in things such as children's allowance, which was payable to the mother. It found expression also in the Murphy decision in 1980. The Supreme Court specifically looked at Article 41 and subsection 2 of it, and specifically relied on the protection that women should not be obliged by economic necessity to work outside the home, to the neglect of their duty in the home, as part of its reasoning in forcing the state to introduce a pro-family tax regime. It isn't a dead letter. It wasn't a dead letter in 19... Francis and Mary Murphy relied on it in the Supreme Court successfully to stop themselves being taxed unfairly. And we had a discussion on this morning about taxation.
Wording and rhetoric.
And this report sets out alternative forms of wording as to how we might amend the Constitution.
The exact wording of a referendum.
However, the language of both Article 4...
not just modern time vernacular, but it has serious consequences.
That wording correct. In relation to the actual wording of the referendum,
When listening intently to the words of our policymakers, it's uncanny how all their rhetoric is so similar. They sound magnanimous and authoritative, but are they really all reiterating similar points? Let's look closer. The language used is almost hypnotic.
All we are aiming to do is have a constitution that respects that equality.
Ireland is a modern, inclusive nation that strives to treat and care for all of its people equally.
Particular remain anachronistic.
Yes, it's a constitutional change that is long overdue.
Where a woman's place is.
I mean, to see that anachronistic phrase in the Constitution, towards gender equality, and yet you had this in our...
The diversity of family and the diversity of care within our country.
Constitution to delete the sexist language about women and mothers currently in it, and to provide for a more inclusive definition of family.
My single dad fathers, I have several friends who are fathers who raise kids of their own. I have several gay couple friends who want to have kids. Are we saying to all those people that they're not a family? It is so backward, it is so archaic, it disgusts me.
Very rarely say this, but I do feel this about that particular clause. I find it offensive. I don't have a place within the home. I have a place wherever I...
Mental day.
Home. One of the ways of dealing with discrimination is to identify it and to end it. Discriminatory language which perpetuates gender stereotypes doesn't have a place.
Examining all the points, these are the conclusions on the 39th Amendment, the family referendum. So first of all, the transgender ideology. The factor of pushing through transgender ideology and an LGBTQT agenda aimed at remodelling society to their vision, creating gender confusion and erasing the word woman from the Constitution. Meanwhile, there is a continued crusade to see transgenderism taught in the country's schools. It may also give dominance to the recognition of woke relationships and surrogacy. And as Cathy Sinnott alluded to, more state control. Now the state are offering a formula of words that will reduce their responsibility towards the family and mother, but increase their control of family. Immigration. Another unforeseen consequence of the constitutional redefinition of what was once considered a family model is that the reference to durable relationships will lead to a significant increase in the number of people living in the state who will apply for other people who they know to come to Ireland. If the Constitution is changed, they will be able to do so on the basis of a relationship that has up to now had to be proven by a direct and indeed legal connection to the partners or children or parents of children seeking residency here. Next, family and durable relationships. But of course, if the Constitution is proposed to be amended to remove any reference to women, then the question as to how the brave new concept of family and the replacement of millennia-old Western definition by a new formula, one that includes durable relationships, is bound to touch on issues to do with the definition of gender. One could also interpret this as a further downgrading of the importance of marriage to society, indicating that the state does not see any special value in the institution of marriage. And finally, family and the Constitution. Article 42, the family is the natural educator of the child. So while this remains in the Constitution, a mother has the right to stay at home and be the primary educators of the child. So a natural law that is enshrined in Articles 40 to 44 of the Constitution, in natural law, the child is that woman's property. So after examining all these points, these are the conclusions on the 40th Amendment, Mother. So the first one is sexist language. Old-fashioned language I accept, but is it all that bad? It strikes me that it is about choice, and there is no choice if a mother has to work to make ends meet, if paying a mortgage or providing for other essentials. This article in no way diminishes any choice for mothers, but casts an obligation on the state to amplify their free choices, whether or not to work outside the home, by assisting those who freely choose to work in the home and would otherwise be forced against their wishes to engage in labour outside the home. This article puts women on a pedestal. The woman is the primary educator, which again, if this is abolished, the state becomes the primary educator. Have we really gone that far, that liberal and progressive, that we want to eradicate the word mother? The Irish mammies from society. This vote is for your mother, your grandmother, your sister, and your granddaughter. This was not always the case, even for the most working class people who could also, in those dark days of Catholic obscurantism, have a reasonable expectation that if they worked and paid their bills and so on, that they might come to own their own family home. It is rather ironic, perhaps, how much of the bucket list of the contemporary left happens to coincide with the interest of capital-driven organisations, always seeking new means of expanding its potential workforce. Number 2, under the current legislation, the onus is on the state. It is clear that the existing wording, a mother who is struggling to rear her family by virtue of remaining working exclusively in the home, would have standing to seek additional financial support from the state. Whereas the revised guarantee might be at best be interpreted as requiring the provision of occasional home assistance or respite to families struggling to care for their elderly or disabled relatives, which already happens in many cases and without any requirement of a constitutional provision. Articles 45.2 provide that the state shall in particular directs its policy towards securing that the citizens, all of whom men and women equally, have the right to an adequate means of livelihood, may through their occupations find the means of making reasonable provision for their domestic needs. Our society is becoming more influenced by societal methods from other regions, example the Middle East. You hear of Irish emigrating to Dubai every day. In Dubai, mothers are back to work 2 weeks after having a baby. Whether it be a section or not, so nannies raise the children. No time or such a thing as breastfeeding in Dubai. It's been forced out. Without this in our constitution, we lose the right to raise our own children and be their main caregivers. So the referendum and the commodification of care. Always question who will financially benefit from a proposed amendment and wonder why those in power are always screaming that it needs fixing. It protects you a little bit more from them. In the neoliberal political framework, there is a core assumption that all services are best provided via the market. Example, privatization of retirement homes. Indeed, some of the more economistic of the old left might have argued that removing what is clearly meant to be a right is just another stage in accomplishing what Marx himself once described as the destruction of all social family bonds that stood in the way of expanding the workforce. Next is a symbolic gesture. As currently formulated, the proposed Article 42b is little more than a symbolic gesture without any prospect of a practical effect. The problem with this is that it would allow future governments to say that something important has been done for carers, when in truth little or nothing has been done. In this way, the proposed Article 42 may impede rather than stimulate positive future change. So how voting yes contributes to surrogacy and increased migration? The current wording in the Irish Constitution gives women and mothers a solid foundation for wider recognition in Irish society and provides a basis on which to strengthen current laws that support women and mothers and their work, including in the home. In the world of technological advances, AI, sex robots, assisted reproductive technology, and gender assignment surgeries, it can be easy to forget that the heartbeat of humanity begins in the womb. Our society is becoming more influenced by the societal methods from other regions. Example, the Middle East. You hear of Irish emigrating to Dubai every day. As I said earlier, mothers are back to work 2 weeks after having a baby. So the word home is removed. We note that the proposed replacement to the section on mothers in the home no longer mentions the home at all. This seems highly significant. Why not mention the home? Why not give special mention to the home and its value to people? For me, personally, it's great when you go home. I definitely feel more peaceful than anywhere else. You can't buy that. Familiar with the roads, the people, and the familiarity. It elicits feelings of security and replenishment for me. But again, this fits in with the overall government philosophy which seems to prioritise economy over the home and wishes as many people as possible to become members of the workforce. And lastly, this is a case for euthanasia. So again, one of the main aims of this referendum of the woman carer in the home, the next step is to remove the children's allowance and then the carer support allowance. Remember, 90% of care is received in the last year of a person's life. Carers and the need for them is on the increase. When one considers the number of disabled students registered with support services has increased by 273% in the last 13 years alone. Is this a sign of a developing nation?
Very quickly, the High Court has, you know, the woman in the home contributes to society. They want to get rid of that. That's one of the referendums. And yet the High Court has found that that can be a man or woman. It's the person who does the caring duties in the home, the person who takes care of children, the sick, the elderly, the disabled, is covered by that article. That is their article of the Constitution. They're not going to tell you that. They're going to say it's an archaic picture of women. But it ensures that they don't have to pay contributory pensions to carers and it's essential to get rid of that in case anyone ever uses it in court and establishes that in policy, because that's going to be in the way of euthanasia. Because if you have to constitutionally have to support carers and recognize their contribution, it's going to be harder to bring in euthanasia. You need carers to be stretched to the limit and whatever. Like Miriam O'Callaghan in Prime Time, or that show last week, show you how terrible it is.